As Megan said, my name is Jessica Tom from Ohio. Go Bucks. Real quick about me, I love animals. I enjoy rock climbing and traveling, and I am terrified of public speaking. Okay, so before getting into the main discussion, I just wanted to put in a quick plug for getting a statute enacted that clearly sets forth your state's prohibited contractual provisions. Ohio does have one. I wrote it. You're welcome. And it really has been a great help in our contract negotiations. So if you're not sure where to get started, I know there are many other states that have them at this point. So if you have any ability to influence that, highly recommended. So I'm here to talk about common negotiation showstoppers, and there's like a million of them, right? I'm going to talk about 3 today: limitations of liability, non-negotiable supplier terms, and data location and access. I'm also going to talk about how Ohio handles these showstoppers as an example, but these practices can easily be implemented in your state, so feel free to borrow. We don't mind. So first, oh, I'm sorry, that was for the statute. First, limitations of liability. Is it a coincidence that the abbreviation for limitations of liability is also that for laugh out loud? Okay, so I'm going to first talk about why limitations of liability are problematic. The concern is that if the supplier's damages reach the contractual limitation of liability and there are still additional damages left over above that limit, the state could be left holding the bag for those additional damages, which in turn could lead to the state having to indemnify another party, which, as we all know, is a huge party foul. While limitations of liability may not specifically be prohibited in your state, most states are prohibited from indemnifying another party. So we just solved the problem, right? Because these limitations could lead to an unlawful indemnification obligation by the state, we can't put them in a contract. Yay! If only it were that easy, right? So what can we do about it? In Ohio, one of the things that we do is we break down the overarching category of damages into smaller subcategories in the hopes of narrowing the scope of the types of damages that are included in the potential limit of liability discussion. So first, bodily injury and property damages. Ohio statute does prohibit including limitations on these types of damages, but for the most part, suppliers don't really have an issue with it. So even if you don't have a statute, then it shouldn't be an issue. So we can check that box and we can remove those damages from the limit discussion. Second, intellectual property infringement damages. Ohio statute doesn't mention this at all, but again, suppliers don't usually have an issue with unlimited liability for these. It's their product, they're responsible. So again, get those out of the discussion. Third, security incident damages. I'm going to come back to that one. And finally, other damages. This is our catch-all category for anything that's left over that doesn't fit into the other categories: breach of contract, breach of warranty, what have you. This is probably the least concerning to Ohio of the 4 categories, and we actually will consider including a limitation of liability on them. Now, I know what you're thinking. Didn't she just say that if we include a limitation of liability in a contract, it could lead to an unlawful indemnification obligation on the state? And you would be absolutely right, but I'm going to ask you to hold that thought for just a minute. So let's go back to security incident damages, which I'm sure is everybody's favorite. And we all know it's very rare that a supplier is going to just accept unlimited liability for these types of damages. In Ohio, our statute does not help us. Our statute actually purposefully does not include a prohibition on including a limit for security incident or data breach damages. And the reason for this is if that it was prohibited by statute, what IT supplier is going to want to do business with us, right? Because nobody agrees to have unlimited liability. So again, we are willing to consider limits on security incident or data breach damages. I know, hold that thought. But we do look at them on a case-by-case basis because obviously no contract, no project is the same. So when we're thinking about what is an appropriate limit for security incident damages in a contract, we want to make sure that we have all the necessary state peeps involved in the discussion. So you have obviously your client, bring in IT security, bring in risk management, as I guess is now a big thing. Bring in legal. Obviously, procurement's in the discussion. If there's anybody in the administration that needs to be involved in making the decision, get everybody to the table as part of the discussion. We then look at the specifics of the project involved in the contract. What types of state data are involved in the project? Is it public data? Is it sensitive data? Some combination of both. And the more sensitive the data, the higher the risk is to the state if a security incident occurs, so the higher we would want the limitation of liability to be. We also look at the volume of state data involved in the project, the dollar amount of the project. The higher the volume of data, the higher the dollar amount. Again, the higher the risk, the higher the limit should be. So we've had our internal discussion. And now, to complicate things even more, in addition to wanting a monetary limit on security incident damages, suppliers try to further limit their liability to only those damages due to the fault or negligence of the supplier. So this is actually a big showstopper in Ohio because if a security incident occurs on the supplier side, in other words, it happens in their environment, and if the supplier didn't do anything wrong, they're not responsible for those resulting damages because we included the tie to the fault or negligence of the supplier. Well, that doesn't seem right. The supplier should absolutely be responsible for what happens in their environment, including security incidents, regardless of whether there's any fault or negligence involved. The state has zero control over what happens in the supplier's environment, and part of what we pay for when we have a supplier-hosted solution is that the supplier's management and security of its environment. Another thing suppliers love to do is to propose an aggregate limit over the life of the contract. We don't like this either, and we try to get the limit to apply per claim as opposed to in the aggregate. And a lot of times the initial limit proposed, it's some multiplier of the contract spend over some past number of years of the contract. The problem with this is the limit becomes a moving target. So depending on when you calculate it, the contract spend is different, and so the limit could be different. So you don't ever really know at the beginning what the limit is, and so you really don't know if it's been met when, if something should happen. The term of the contract could also change with extensions or renewals, and when you have that static liability limit in the aggregate, extending the contract whittles away at the appropriateness of that originally negotiated limit. So, of course, you can always amend the contract, but, good luck with that. So I told you to hold the thought that including limitations of liability in a contract could lead to indemnification by the state. And I know that you have just been dying to know why. So in Ohio, when we do include limitations of liability for security incident or other damages in a contract, we always include disclaimer language after the statement of the liability limit that says, to the extent such limitation does not impose an unlawful indemnification obligation on the state. And by including this language, not only does it address the indemnification concern, but it also essentially negates the limit that we've just stated. So like I talked about, if something happens and we reach the limit, the damages limit, and there's leftover, if it results in the state having to indemnify another party, this language says no, 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 and punts it back on the supplier. And surprisingly enough, suppliers don't have much of a concern including this language. So we've had a lot of success using it. So showstopper number 2, what if your client wants to make a purchase, but the supplier insists on using its own terms and will not negotiate them at all? This is tricky because you don't want to tell your client no. They can't make the purchase, but you also don't want to just let it go forward knowing that there are problematic provisions in the supplier's terms. And of course, your client is going to insist that they need the contract, despite the supplier not being willing to negotiate. And when this happens in Ohio, we use what we call a required provisions letter. The letter outlines the specific problematic provisions in the supplier's terms, explains why they are problematic, and then also sets forth the provisions that must be included in every contract with the state of Ohio. It then goes on to say, because the supplier isn't willing to negotiate, it's assuming the risk of having those included. We then advise our clients to send that letter to the supplier before making the purchase. And every once in a blue moon, a supplier will come back and be willing to negotiate after receiving the letter. It doesn't happen very often, but we'll take those little wins, right? It's not a perfect solution, but it's better than doing nothing. And the final showstopper I'm going to discuss, data location and access. So many states have a statute, rule, executive order that prohibits services from being performed or data being located outside of the United States. Ohio actually has 2 executive orders on the subject. This is another sticky situation, and unfortunately, I don't really have any great solutions for you on this one. What I will say is to make sure that you are getting all of the information from the supplier that you possibly can about where services are and where the data is. Ask questions. So the supplier says it's not performing any of the work offshore, but where are your support personnel located? Do you use the follow the sun model? The supplier says it's not storing our data offshore. Great, but where are you accessing it? Okay, so you are accessing our data offshore, but who is accessing it? Is it your back office administrative staff? Is it your software support personnel, your key project personnel? The supplier says, we're doing everything in the United States. Amazing. All those same questions. Where are you accessing our data? Where are your support personnel? We really need the supplier to be transparent about this and get as much information as possible. In Ohio, in order to gather the information, we use what we call the affirmation and disclosure form. I know this is tiny. This is actually available on our website, so if you need a link, let me know. And on the form, we request information about the suppliers and its subcontractors, business locations, where the services will be performed, and where the data will be located, which includes stored, accessed, backed up, etc. So you have all this information, lovely. Don't just get the information, use it. Talk to your IT security team, talk to your client so that everybody understands what's going on with the services and the data and you can take appropriate next steps. At the end of the day, All we can do is advise our clients to the best of our ability within the constraints of our state laws, some of which are helpful, some of which are just frustrating. And with that advice, should they choose to accept it, our clients can make informed decisions. I hope you got some takeaways from this. If you have any questions or want to further discuss anything, come say hi. If you can't find me because I am the shortest person in the room, you can hit me up in the app or email me. Thank you so much, and I'm going to go pass out now.